I just have to tell you that from Justice Peterson's perspective and myself, the judges and the lawyers who lectured yesterday and demonstrated were first rate. Okay? What you saw there is the way it's supposed to be done, not necessarily what those clips show you on the videos. Okay? So for example, when Tom Cruise asked the witness in A Few Good Men, when he asked Jack, what's his name? Nicholson, when he asked him, why did you do that? One of the cardinal rules of cross-examination is never ask why, particularly when you don't know what the answer is. Okay? But what you're going to see is I'm going to talk about cross-examination, and what I'm going to say is going to be consistent with what Judge Hernandez started with, what District Attorney Haraldson said. You have a theme of your case. Okay? Everybody understand what we mean by a theme of the case? Who doesn't get that? So what's the theme for the defendant in this case? Right, not responsible, right? It's the plaintiff's own fault. Right. All right? So that's the theme that the defense wants, and you saw it from the very beginning. When the lawyer gave his opening statement on behalf of Cup of Joe, what did he emphasize? You know, this is a tragic accident, but we're not responsible for this. Okay? So the opening statement is we're not responsible. Okay? Then when you see the direct examination, those questions are intended, if you're on the defense side, to show they're not responsible. So let me just make a couple of comments about being a trial lawyer. I think most of you would agree that brain surgery is a very complicated and risky undertaking, right? So a person who is a brain surgeon has gone through all kinds of education. They went to high school, went to college, went to medical school, went to advanced medical training. They learned everything about the brain. Okay, they know everything about the brain. And so when they operate on somebody, they have all of their accumulated medical knowledge and expertise, and they put that to bear, and then they need to be able to use their hands to manipulate the instruments and the variety of things that they do. So brain surgery requires the brain surgeon to have this accumulated knowledge and the manual and physical dexterity to operate on something as complicated as the brain. But all a brain surgeon has to do is control him or herself. A trial lawyer in a trial is trying to control every aspect of the trial and of the participants. So first of all, the trial lawyer is trying to control him or herself, so that he or she always appears a certain way in the case. Okay? So you're trying to control how you appear. You're also trying to control the jurors. And one of the ways that you're trying to control the jurors, as Judge Hernandez says, is to get them to trust you. Okay? And you develop that trust by how you comport yourself in the courtroom. You remember Judge Hernandez said, when you speak to the judge, you stand up and you address the judge respectfully. Your Honor, I object to this for this reason. Or, Your Honor, may I move about the courtroom? Whatever it may be, but you show that respect. And I can tell you this is true. In a murder case I had, a reporter for the Oregonian interviewed the jurors afterwards, and they said one of the most important things to them was how I treated them respectfully, how I treated the judge respectfully, and they believed that I believed in my client's innocence. So they were observing all of those things. So a trial lawyer is trying to control him or herself, trying to control the jurors, trying to control the witnesses, and, this is not easy, trying to control the judge. Okay? Many people have said that's more complicated than brain surgery. Okay? So that's what being a trial lawyer is about. Now, we heard opening statement, we heard about direct examination, and now I'm going to talk about cross-examination. To set the stage for that, what I want you to understand is our judicial system, that's part of what you're learning about, the way we adjudicate cases, our trials, are premised on what's called the adversarial system. Remember that word, it's called the adversarial system. We're one of the few judicial systems in the world that relies on the self-interest of each party to bring out the facts in front of the jury. In other words, we rely on the self-interest of the parties to bring out the facts and achieve justice. That's rarely the case in most other countries in the world, where we rely on the party's self-interest. So one of the key engines of the adversarial system is the ability to cross-examine the other side's witnesses. Okay? Much has been written about cross-examination. There are whole books on it. This is just one of them. Okay? There are books and books about the subject of cross-examination. All right? The reason is it's dangerous. It's where lawyers make mistakes. Okay? In fact, what I learned as a young lawyer, I had retained an expert witness, a psychiatrist, to testify on behalf of my client. And I went up to see the psychiatrist to get him ready for his testimony. And I had a million questions on direct examination. I'm going to ask you this, 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 I'm going to ask you this. I want to hear your answers. And he said, listen, young man, I'm going to explain something to you. Just ask me a few questions on direct examination. I'll get all the good stuff you want out on cross-examination when the other side cross-examines me. That's the way real experts think about how they deliver information in the courtroom. Okay? So what people commonly think about cross-examination is you're going to devastate the other side's witness. You're going to devastate that witness. The answer is rarely. What you want to do is by your questions on cross-examination, you get to testify. Because you get to ask leading questions. And those leading questions are, you put them in the form of statements of fact with which the witness should agree. Okay? Does everybody get that? Short questions, because you want them to be understandable. For example, Mr. Witness, you agree the light was red. Easy, simple question. That's a leading question. Okay? You agree Ms. Garcia was driving an SUV. Correct? Yes. Okay? So these are simple questions. Okay? The goal here is to advance your theory of the case or your theme of the case by giving the jurors information. Okay? By giving them information through your questions with which the witness must agree. Rarely do you reduce the witness to this quivering mass of jelly. Okay? And in fact, when you think you've done that, you've probably made a huge mistake. Okay? Because jurors are human beings. And who do you think the jurors have sympathy for? Not for the lawyers. The witnesses, right? Okay? I'm going to give you a true story. This is a true story, very helpful to me when I was a young lawyer. I happened to be retained to defend the district attorney of this county who was accused of crimes. The top law enforcement person in the county was subject to a criminal indictment. Okay? And I thought the person hated me, the district attorney, because I had caused him a lot of trouble in court. Well, apparently because I'd caused him a lot of trouble in court, he wanted to hire me to defend him. So this was the largest criminal trial, one of the largest in the state's history. It took place here in Marion County. I was 5 years out of law school, and you had to get a ticket to get in the courtroom. Standing room only. You had to have a ticket. So I started cross-examining a lawyer who was a witness against my client on a Friday afternoon. And the Oregonian reported in the Saturday morning paper a number of details about this cross-examination and ended the article with, "And that cross-examination will continue on Monday." So my mother read that. She said, I'm going to take a day off work and I'm going to come down and see my son cross-examining this lawyer that the Oregonian reported about. Just like I used to watch him play football, basketball, baseball, I'm going to come watch this. So I cross-examined this lawyer all morning. And to use the sort of common phrase, I beat the crap out of him. Okay? I beat the crap out of him. Verbally. So that cross-examination ended about noon. And I went out to lunch with my mother. Stone silent. I said, what's the trouble here? I said, you just saw me in front of standing room only courtroom. I beat the snot out of that guy. Silent. I said, well, what's the trouble here? What? She said, do you want to really know what I thought? Yeah, I'd like to know what you thought. She said, what I thought was, I never raised you to humiliate another human being like that. So what must the jurors have been thinking about me? Okay? What must the jurors have been thinking about me? They probably thought, what a smartass. Okay? All right? So my point is here, you rarely does it do any good to even think that you're going to humiliate some other person in the courtroom. Okay? What you're trying to do is impart information, get the jurors to trust you, to believe that you're competent, that you are a guide that can lead them through the story, okay? And lead them through to the facts, to the true facts. That's what you're trying to do. And so what you want at the end is you want the jury to have thought that you were a pretty good witness yourself by your leading questions, by giving information, that you're trustworthy, competent, that they can rely on what you do and say in the courtroom. Now, there will be times when you have to do various things with witnesses. You have to neutralize them about something. You have to set up their testimony for another witness who's going to be coming along next. Okay? You have to think ahead strategically. Okay? So the way you do this as a practical matter, so if you have Dolores Cervantes' testimony, right? You have her statement in your books. So if you were preparing for cross-examination, you would first think, what's the theme that the plaintiff is going to try here? What's their general theme? Now, we know what our theme is. We're not responsible. So we need to select some topics that we want to cross-examine on. All right? And then we got to figure out the order in which we're going to ask our questions. Some of you may have heard these terms already, but there's psychological terms called primacy and recency. What they mean is, just to use common phrases, you want to begin with a question that elicits a strong point for you, and you want to end with a question that elicits a strong point for you. So you begin and end, and then you place your questions in there. Now, one of the things that I think is important in achieving this trust and fairness is you don't ask every question as a leading question. Okay? Some of the questions can be open-ended, like you do on direct. You know, tell us about this, do that. Only if you don't care what the answer is. In other words, only if there's nothing the witness can say that will hurt you. Okay? And so the point is to sort of sprinkle those in there. But you don't have to do that. But that's just sort of icing on the cake. If you have little questions that you can ask, open-ended, tell us about this, do that, and you don't care what the answer is. Okay? So you're a storyteller, you're a guide to the facts, you have short declarative statements that the witness should agree to. And then if you want to know 9 million other things about cross-examination, you can read one of these books. Okay? And so I think we're going to start on our demonstration.